Ms. Pumphrey, good morning.
Good morning. May it please the Court, I'm Janet Pumphrey for Jacques Robidoux. I think the place to start in understanding this case, because this issue sort of permeates the whole case and it permeates every argument, is that Jacques Robidoux was not competent to stand trial. He was never tested, he was never evaluated, and his trial decisions and his ability to cooperate with his defense counsel, he was not competent. You have only to look at his pro se motion to change plea, which he filed on the first day of trial. He tried to fire his lawyer on the first day of trial, tried to proceed pro se, represent himself, and that motion to change plea makes no sense whatsoever. I would direct the Court to page 18 of the appendix in paragraph 5.
Most pro se motions don't make any sense whatsoever.
This makes less sense. I'm just going to quote from one paragraph. Defendant and his wife, on the 29th day of May 2002, declared their independence and expatriated themselves, as well as their estates, from the Foreign Municipal Corporation of the District of Columbia and its 14th Amendment Public Charitable Trust, using public municipal law for private purposes. That makes absolutely no sense. And I think it gives us a valuable clue into Jacques Robidoux's mental state at the time when he was tried. Between the time of the events and the time of trial, he was continually visited by cult members, and he was under their influence all that time. The Commonwealth attempts to legitimize these rantings in the motion to change plea as beliefs of the, quote, sovereign citizens movement, which is discussed at Wisconsin Law Review 1999, beginning at page 785. And even if it is true that there's some kind of a movement that shares these beliefs, it doesn't make those beliefs rational. They make no sense whatsoever.
But at the time, there was no affidavit or anything from any expert that he was incompetent.
There was no evaluation. This is the kind of case that just... When the judge questioned him about going pro se, as I recall, he gave answers that the judge could find, showed an understanding of the proceedings and, the test for competency. He made a conscious decision not to be examined by a forensic psychiatrist or psychologist with reference to a possible insanity defense. This all adds up to being competent. And I think the judge also found that many of his answers were clear and lucid.
Correct.
He's a very, very, very bright man.
Yeah.
But he was psychotic. He was delusional. And I think the facts of this case, shout out that he was delusional. And I think that defense counsel had an ethical obligation to have him tested. And the court, I think, even the prosecutor has an obligation to have him tested if there's a question as to his competence to stand trial. And I would just suggest that the defense counsel should have seen red flags when he asked his client to see a psychiatrist for the possibly presenting an insanity defense. And Jacques answered that he believed that the medical system was one of Satan's counterfeit systems. I mean, that should have just jumped out at defense counsel. That's not a logical, rational answer. He had an ethical obligation to raise a competence issue, and he should have reported to the court and had the court order his client to see someone for an evaluation. Other jurisdictions have reversed convictions on grounds that the defendant did not receive effective assistance of counsel, where counsel failed to investigate competence.
But I take it he didn't. I mean, he testified at trial.
He testified at trial.
And he wanted to tell his story.
He did.
He wanted to, in essence, say that it was his responsibility because he had I mean, all of this is quite rational. You may not agree with the strategy, but it's his decision, and it appears that the judge finds that there was no evidence of the fact that he didn't understand the trial process, couldn't consult with his counsel, that there was no evidence of that at all, quite to the contrary. So what are we supposed to disregard all that?
Well, I would suggest that when he got up to testify, and I think that to a tremendous extent this does indicate that he was not competent to testify. His testimony really was a confession. He basically told the story of how they starved the baby to death, and he took responsibility for that. And I think
what was the defense here?
The defense here there was an expert. Jacques Robidoux testified first for the defense, and then they put on an expert whose testimony didn't last very long, and who basically said two things. the baby could have died of,
Oh, yeah, that's right.
scurvy.
Yeah, correct. Yeah.
Which also goes to vitamin deficiency, which also goes to starvation. And also said that the baby could have either died of, the cause of death was either unknown or was starvation. And then he said too that only 2% of all the cases that he's seen are unknown causes of death. So he basically made the Commonwealth's case. Second,
But what's the defense lawyer supposed to do when the defendant up front tells him he doesn't want any part of an insanity defense, doesn't want to be interviewed?
well, I think that he had an
psychiatrist?
obligation to go to the court and tell the court that he believed his client was not competent, and the court should have ordered a psychiatric evaluation for competence, because I don't believe that Jacques Robidoux was competent when he was tried.
Now, we're doing this on the face of the transcript. There's been no
Well, the face
motion
of the
for-
transcript and 2 affidavits.
Well, yes, but no motion for new trial where
There-
Yeah.
There was.
the defense counsel
Yes.
testified?
No, there was no hearing.
Oh, okay.
Um,
Yeah, there was, okay.
Did the defendant ask for a hearing?
Yes. Failure to assert an insanity defense. Again, I don't believe that Jacques Robidoux had the competence to understand that the insanity defense, that was the only viable defense that he could have possibly put forward.
And that argument only works. I mean, the competence is really,
The competence is key. The competence is key. If he's not competent to understand that he had to put forward an insanity defense, because this insanity defense was very, very viable. He was not a sane person. He was completely psychotic and delusional. But he didn't, because he wasn't competent at that time, he couldn't agree to an insanity defense or not. He could just say, I don't want to see a psychiatrist because that's, Satan's counterfeit system.
but I mean, because you would agree that if somebody is competent,
They
no
could
matter how
absolutely.
crazy they might have been at the time and what a viable insanity defense, tough luck if
They
they
could
don't want
choose
to assert it.
Exactly, but but he just was not competent. And I think if you read that motion, he's very, very bright, so he was able to answer questions. But if you read his motion, and also read his diaries, because the diaries came in also, he was psychotic. This
But
case
being
should have.
psychotic doesn't mean you're not competent. I mean, it just doesn't mean you're not competent.
Well, that's true, but I don't. But
And the
if
judge had him in the courtroom. The judge, questioned him with respect to his motion to relieve
right.
counsel. And,
That's right.
And went through a whole.
He's very, very bright. He was very able to answer questions. But I don't think he could cooperate with his attorney, and I don't think that he was able to decide to waive the insanity defense, basically. He should have been evaluated. I mean, it would have been it would postpone the trial for perhaps as little as a couple of weeks. But if he was not found competent to stand trial, then the trial should have been postponed until he was competent. This case should have been tried under an insanity defense. The McCool standard sets out an alternative and not a conjunction. A defendant is not criminally responsible if he lacks a substantial capacity, not just the complete capacity, but substantial capacity to appreciate the wrongfulness.
Affidavits from, they never talked to the defendant.
They never talked to the defendant, but they were very, very aware of this case. Both the psychologists had followed the case from the beginning. They both testified at Karen Robidoux's trial, and one of them was involved in the care and protection case as well.
But isn't it kind of fundamental? You got to at least talk to the defendant?
Yeah. Well, I think that they both knew the facts of this case backwards and forwards. They both sat through Karen Robidoux's trial. One example is the trip to Maine. The Commonwealth justified as appropriately held religious beliefs that the cults taking their young children and driving to Maine without money for food or gasoline was appropriate religious beliefs. After the first car ran out of gas, they stopped at McDonald's to pray for food or money. When the second car ran out of gas, Jacques believed he could put his hands on the car and pray, and that gas would come into his car. And while most religious people believe in prayer, nobody believes that you can get gas in your car without going to a filling station. After the group returned home, Jacques and Roland was the father. Jacques and Roland believed that the Maine trip had failed because they were not willing to give up their children to God. They were not willing to basically put their children in God's hands, and it was a test that they had failed. Equally as instructive of his delusional thought processes were the facts of this case. He believed in the leading that he must stop feeding his child. Samuel was
Also said at one point, or testified, or there was evidence to the effect that he could put the leading on hold if he wanted to.
There was, but he basically couldn't do it, though. He testified that he could perhaps have put it on hold, but he couldn't. In the 51 days between the time that they got the leading and the time that Samuel died, they took the baby off of solid food, and this was off of solid food while Karen was pregnant with her fourth child. And in the middle of this, Jacques began to doubt, and he started feeding Samuel almond milk, whatever that is. And but he went to Roland, his father, and Roland said, "No, you can't feed the baby almond milk. The baby has to just have breast milk." And Karen was not producing breast milk, so he was not able to put the leading on hold.
Well, then he stored the dead baby.
Then he stored the dead baby.
I don't know, 3 or 4 months or something.
For 3 or 4 months
and then buried him in the state park up in Maine.
Baxter State Park in Maine.
Doesn't that show he appreciated the wrongfulness of his conduct?
No, I don't think that it does, because, the Commonwealth argues that that's consciousness of guilt. This is a case of a cult that they didn't believe in doctors. The women who were pregnant didn't go to obstetricians. Babies didn't go to pediatricians. They didn't believe in bank accounts. They didn't believe in eyeglasses. They had absolutely nothing to do with the outside world. So for them to call a funeral director at a time of death would have been just outside of the realm of what they did. To bury their dead in privacy, it all fits with what they believed. The Commonwealth also argues that Jacques' emotions, his understanding or his appreciation of Samuel's condition, suffering, and ultimate death illustrate the wrongfulness of his conduct. That logical leap, I think, is untenable. Jacques loved Samuel. He loved Samuel. He loved his child. The fact that he was distraught over Samuel's suffering was indication not of a appreciation of wrongfulness, but just his delusional thought processes. I would suggest that the first McCool alternative was easily satisfied under the facts of this case. And the second McCool alternative, the Commonwealth makes very little argument on the second prong, and this is an alternative that Jacques was wholly unable to conform his conduct to the requirements of law. He believed his obligation was to God's law and not to the law of the Commonwealth. He believed he had no choice in the matter. He led a life of lifelong brainwashing, and he was incapable of not following the directives to stop feeding his baby.
Why don't his journal entries indicate that he appreciated the wrongfulness of his acts and that he was capable of conforming his conduct to the law?
I think if you read them, what the journal entries to me suggest is really a delusional thought process, that he just believed if he stopped feeding Samuel, and then if Samuel died, it's very clear in the journal, if Samuel died, that he could put his hands on Samuel and bring him back to life. He believed that, and he was unable to stop. He was unable to feed Samuel, and he did think about it. He did think about putting it on hold, but he was unable to do that.
So when he tells his defense lawyer, I don't want any part of an insanity defense, I won't be examined, all this and that and the other thing, the defense lawyer was supposed to bring this to the attention of the judge and then resign from the case?
No, I think
saying I can't defend this man?
No, I think just ask for a court order that he be evaluated by a psychiatrist for competence. And then if he's found competent by a court evaluation, then he's competent. But I would suggest that he was not competent to make any of those decisions. I think when
we're left with the affidavits of 2 post-trial people.
That's right.
Neither of whom examined it.
That's right. But they were both very familiar with the case.
Well, I know that's what you said, but I don't know.
And the difference between this, and there really is very little difference between this case and Karen Robidoux's case. She was also tried for murder. She was found not guilty of murder. But that case was tried completely differently. It was tried under a battered woman's syndrome case, and basically that she was under the undue influence and duress of Jacques and Roland, Jacques' father. And I would suggest that this case is exactly the same. Jacques was under the undue influence and duress of his father. So if there's a battered woman syndrome for Karen, there should be a battered son syndrome for Jacques.
Was Karen found competent to stand
Not
trial,
guilty.
obviously?
No, but Karen was not.
But I think that the woman's defense is much different than this defendant's defense. many two-defendant murder cases, joint enterprise, one defendant is under the sway of the other. I mean, that's very common. So, and that doesn't make out an incompetent to stand trial defense.
Well, I think that it does. I mean, in a way that her mental issues were brought in. That's how it was tried. Her case was tried on her mental issues, and this was not.
No, but I'm saying that it seems to me, at least, that her case was very, very different. She resisted the restricted diet. She questioned it. She cried. There was evidence and there was evidence she was battered and brainwashed. And there was no such evidence with this defendant that he questioned things, that he didn't want to do it, that he cried.
Well, I think that he did. He didn't cry, but he did question, as Judge Graney pointed out. He did question because he thought that perhaps he could put the leadings on hold, but in the end he couldn't. And in the end she couldn't either because she's the one who was not feeding the baby. To me, she's the more culpable.
But she must have been competent. I mean, you would not question her competence, right? She went to trial.
She went to trial, and I can't tell you whether she was evaluated for competence or not, but I know she did go through deprogramming before her trial, which Jacques did not. He went straight. He was in prison, and the cult members continued to come to see him while he was in prison and did not go through any deprogramming.
But how can you force it, as Justice Graney keeps asking, if the defendant tells
Well, the court could have ordered it. The court could have ordered a psych evaluation for competence. I mean, not for competence. And if he's not competent, he shouldn't have been tried until he's found competent, until either through psychotherapy or drugs or whatever, he's found competent. And then he can decide how to try his case. But I just, to try it in any other way other than an insanity defense, there really was no other defense, especially when he gets on the stand and takes complete responsibility. I mean, the Commonwealth argues in its brief that the defendant wanted to testify and take responsibility for his conduct instead of blaming it on his mental impairment, but that's a plea, basically, and not a trial. He basically got on the stand and confessed. Even his defense counsel asked, "Do you now feel that you were wrong in following the leading?" And he says, yes. And that was the defense counsel's last question. And then the district attorney picks right up on that, and he says, you stand charged with the murder of your son, and now you think there were mistakes made? And he says, yes. It was a confession. That's not a competent person testifying. It's as though defense counsel hoped that the jury, without the benefit of jury instructions and without argument of counsel, would
doesn't
find
that
insanity.
show that he's competent? He now realizes there were mistakes made.
But he shouldn't have testified like that. He either shouldn't have testified
he should
at all.
testify to things that aren't
basically
true?
He's confessing on the stand, which is, it's a plea. He's confessing. And
Well, doesn't that go to intent? I mean, whether he intended, premeditation and intent?
well, it does go to intent, but I really believe this is a third-pronged malice case. But it's as though defense counsel hoped that the jury, without the benefit of instructions and without the argument of counsel, would find insanity and would acquit. All of the I'm running out of time and I've got two more issues. All of the other example, the multiple examples of testimony of the other times when they went to Maine and they starved their children, they didn't feed the children, all of that came in without objection. And again, it's as though defense counsel wanted the jury to find insanity and acquit. But that's just not the way it was tried. It was tried with this expert who basically said it could have been starvation. I would suggest the only viable defense here was lack of responsibility. I want to get to my other two issues before the 33E issue. If ever there were a fact-bound case that jumps out as needing 33E treatment, I believe that this is it. Karen Robidoux was acquitted on murder and was convicted of assault and battery. That's a much more, that sentence is much more, or the conviction is much more consonant with justice than first-degree murder in this case. The Miranda issue. The officer who interviewed Jacques testified that after Jacques received his Miranda warnings, he was quite willing to talk, but when asked about Karen or Samuel, specifically the circumstances that surrounded the death and the location of the body, he kept saying over and over again, "I'm not going to talk about that, I'm not going to talk about that." So the officer essentially testified that Jacques responded to those questions with silence. He had an absolute right to respond with silence, but that those post-Miranda warning silence cannot be used against a defendant. And there's no interpretation of that specific silence that's not inculpatory. And then finally, the the prosecutor misstated the third prong malice standard. He basically in his closing argument said, any reasonable person in those circumstances would know that the actions they were taking were a clear, plain, and strong likelihood that death would follow. And that, ladies and gentlemen, is the definition of murder. It's not. He's not getting to the subjective part of it, and that's this case.
Thank you, Ms. Pumphrey.
Thank you.
Sullivan Puccini.
Good morning. May it please the Court, Sharon Sullivan Puccini for the Commonwealth. This case was not an insanity defense. The defendant was not brainwashed since childhood, as he claims now in his brief. He was not denied the ability to think or reason for himself since he was a child. This group that was formed, this religious group, started out as a Bible study group. First, the defendant's family belonged to a worldwide Church of God in the 1980s. In the 1990s, they started a Bible study group with Roland giving sermons and teachings to the group. It wasn't until 1996 that the group became a little bit more radical in their changes and their thoughts when they were introduced to a book called Born in Zion.
Why didn't the defense lawyer at least ask for a competency exam?
Well, I think there was no issue of his competency at the time.
But what harm would it have done if it came back and said he's competent?
Was there competency in Karen Robidoux?
Yeah, Karen's case actually was postponed a number of times. She was found not competent. I believe it was numerous times. And then when she finally became competent, they had the child.
But getting back to the question, what harm would it have done?
To hold a competency hearing at the time?
Yeah.
Well, there was no issue at the time.
Well, you're saying there's no issue because the defense counsel didn't raise it?
No, because he didn't have to raise it. The competency is determined on, the focus is the defendant's functional abilities.
Okay.
And there was no issue. There's only a requirement for a judge to have a hearing where there's a substantial issue of possible doubt. This judge was assigned to the case in June of 2002. She had been through numerous motions, interacted with the defendant and his trial counsel from January until the trial was in June. What happened after jury impanelment, the defendant indicated to his counsel that he wanted to proceed pro se. So at that time, the judge held a hearing with the defendant, and I would suggest that her hearing with the defendant, the question she asked, is relevant to us now looking at the case and determining that the defendant was competent. This issue was raised in the motion for new trial. The judge indicated that the defendant was competent. When she asked him questions, he indicated that he had a rational and factual understanding of the proceedings. He understood the knowledge of the rules of evidence, examination of lay and expert witnesses, the filing of motions, and the consequences of competent representation. He knew that the Commonwealth had 3 witnesses. He had represented himself before in juvenile court, although he indicated only in the least of terms. And there was no events during the trial indicating that he had any problems understanding the legal process. He also had the ability to consult with counsel. He indicated during the hearing that he had been involved with the preparation of the case with his counsel. His affidavit that he's filed with his motion for new trial, there's no indication in it that he had any problems consulting with his attorney during the time. After the hearing that the judge had, she told the defense attorney asked if he could have more time to speak to his client because his client had said, I want to represent myself because I don't think we share the same philosophies. There's certain motions I want to file. So the judge allowed them, they recessed for the day, they allowed them to talk, and the next day she indicated that, the next day before she indicated her ruling, she allowed him to present motions. The motions that we're talking about are the motion to change his plea and a declaration of independence. And I would suggest that those motions are not delusional thought process. These were actually ways of the defendant trying to delay his trial.
Did counsel come back and report to the court? You said the judge told counsel wanted to speak to his client. Did counsel come back and say we've resolved our differences?
There's no indication of that. She indicated that had you spoken with your client, yes, and she said, I'll let you present those motions. So he did. She says he asked to go to probate court to present those motions. He said, I'm going to deny it. He said, thank you. Then she said, I'm now going to deny your motion. The defendant said, I thought you already denied the motion to proceed pro se. I thought you already did that yesterday. No, but I'm doing it now. He said, thank you, and they continued on.
So
There's no
basically,
indication that they were not able to.
yeah, basically what you're saying is by the time of trial, the defendant realized that he had misinterpreted God's message and wanted to, in effect, get it off his chest and testify that he had done something terribly wrong.
Actually, the defendant's...
That necessarily is not the actions of an incompetent person.
Correct, Your Honor. And actually, his testimony indicates that the summer after Samuel
It's
died...
the actions of about 95 or 98% of all defendants who are competent and plead guilty because they recognize their conduct was wrong and they want to get it off their chest.
Correct. And he indicates in his testimony that 2 months after the baby dies the end of April, in the summer, he says, he realized at that time that, we had made mistakes. I understand that my conduct was wrong. So just months after this happened, it wasn't just before trial that he realizes, I'm going to take the stand and take responsibility. He realizes this, just a short period of time after all this happened. So he was competent to make a decision not to present the insanity defense. And I would suggest that an insanity defense is not even supported by the record. There's not lifelong brainwashing by this defendant, as I previously said. He wasn't appointed an elder of the group until he was in his 20s, which was like 1997, early 1998. The group members looked up to him. They respected him. The defendant's testimony indicates that no one forced him to follow the leading restricting his son's diet. He testified, the buck stops here. No one can make me do anything. He indicated that his family was close, but they still had personal lives. The trip to Maine, the defense tries to say that it was a part of his delusional thought process. But he shows that he's able to rationally decide during that time that this trip's not working. There's no food, there's no gas to put money, there's no money for food, there's no diapers. So he was not incapable of following God's command. He shows with the trip to Maine that he can reject a leading and follow what he wants to do.
And the affidavits the judge, I think you would say, could reject because neither of the so-called experts or the experts interviewed the defendant, talked to him in any way.
Correct. The defendant Karen's cases, the defendant claims, are identical. They are not identical. Karen was tried under a battered woman's type syndrome, that she was emotionally impaired by Jock and the defendant. She was pregnant, nursing a child. The leading made her nurse the baby for 20 minutes every hour. There's testimony how distraught she was. She couldn't even bathe the baby. She couldn't even hold him. She was so distraught at everything that was going on. And the judge in the motion for new trial also indicated that the jury in Karen's case found her guilty of assault and battery, rejecting even a defense of diminished capacity. And as I said before, the defendant was not subject to mind control like Karen might have been. That was her defense. And these supposed experts did not interview the defendant. The strategy that that defense counsel used was he focused on the cause of death of the baby. He really didn't have much to go on. Here he had a defendant who was going to take the stand, take responsibility. This defendant did not want to be examined by a forensic psychologist so that they could discuss an insanity defense. And the facts and the journals indicate that Jock appreciated the consequences of his actions.
Can I ask you a question? You just said something before that maybe I just didn't understand when I read the judge's decision on the motion for a new trial. Mm-hmm. Karen Robidoux was charged with first-degree murder?
Second-degree murder.
Second-degree murder. And she was found guilty of assault and battery?
Assault and battery.
And that's evidence that the jury rejected the diminished capacity?
Correct.
Okay. I just don't get that. But
okay. I think what they're saying is, in other words, what she argued was that
they certainly accepted
he would have been acquitted if they accepted.
Diminished capacity is not really a defense. It's just it just goes to the mental state.
Right. Or
they probably
that she would have been acquitted if they bought her.
They probably just felt she was, I think Judge Cowan alluded to this, just a kind of a pawn in this whole thing. And, you know, we got to find her guilty of something, but clearly not murder, so assault and battery is it.
So her defense was not insanity. It was
No.
diminished capacity.
No,
Sounds pretty successful.
more like
to
an
me, but
emotional
that's just me.
distress. Emotional distress. And like I explained, the two defendants were totally different. Here we have the defendant who was supposedly being controlled by his father. This is the defendant controlling Karen to follow the leadings. The defendant was clearly aware of Samuel's suffering. He knew even on the first day that Samuel was feeling the effects of being withheld solid food. His journal entries and his testimony are clear indications. In his journal on March 7th, which is the first day that Samuel was taken off food, the defendant writes, "Samuel is obviously not being filled. He was thirsty and hungry." A week later, he writes, "Satan used the physical sight of Samuel to really get to Karen. He was obviously losing much weight and becoming much weaker." He testified that Samuel had been a chubby, robust, happy baby boy. He was able to cruise furniture. He had started to pull himself up. He was playing with toys, picking up toys, rolling over, taking his first steps. He was able to crawl. And just weeks later, the defendant indicates he's unable to move. He's losing weight. You could see his bones through his skin. And he cried consistently. Even on the first day, the defendant knew that Samuel was thirsty. Karen had gone to bed. The baby had been breastfed, and he was crying constantly. The defendant has the baby. He doesn't know what to do because the baby's crying. So he says to Karen, "Did the instructions include that I could give him almond milk?" And she didn't know. So they called Michelle Mingo, who's the one that had the leading, and indicated that the instructions that Karen was only to breastfeed. And she said, "No, that's not food. You could give it to him." So the defendant put almond milk in a bottle and fed the baby, and it satisfied him. So on that first day, he appreciated the consequences of the wrongfulness of his conduct. He knows the baby's suffering, even on the first day. And what does he do? He acts rationally, and he feeds that baby. The baby falls asleep in his arms. So from day one, he knew.
Why couldn't you look at that as, that he has no intent to hurt the baby, but he thinks he's being led
But this
otherwise?
wasn't tried on deliberate premeditation. This was tried on third-pronged malice and only instructed on that case.
Right, but you have to have, you've
He
got
had
to
intent
have,
to starve. He had intent to withhold food from the baby, solid food, after the baby had begun eating solid food. He knows his wife's breast milk was diminished and that the baby wasn't being satisfied, wasn't being nourished. He admits to all that.
I mean, I think it could equally go to not appreciating, I understand you say the wrongfulness of his acts, but that it does go to, could be looked at, I'm not saying the jury has to agree, but it could be looked at as
But
somebody who's not
those are not
acting
the
very
only
rationally.
things. That's not the only thing the first day. He also indicates in his journals that he's expressing doubt about following the leadings. He talks about how Karen is getting upset, and he writes that he had gone for a walk to pray all about this because all of this weighed heavily on his heart. He's expressing doubts. He's understanding that what he's doing is not right.
Well, I guess what you're saying is the question for us legally is whether the judge in effect made a finding he was competent, in effect, and whether there's enough evidence to support that, even though there is evidence that might not support it,
Correct.
as there is in every contested issue, or evidence that could be argued both ways, supporting it, not supporting it. And your answer is there is enough evidence
There's
based
enough
on all the
evidence that
stuff
he was
you've been
competent.
telling us.
And the reason he didn't put on an insanity defense is because
The same thing.
he understood the consequences, the criminality of his.
Why didn't he enter a guilty plea?
Yeah.
That's a guilty plea.
Why did he not? He doesn't indicate in his affidavit.
I'm
why he
not
didn't.
saying why
Yeah.
didn't he,
I
but I'm
know.
saying the fact that he doesn't enter a
Well-
guilty plea. There are people, as Justice Glenn
Well, he
said,
didn't get up on the stand and say, I want you to find me guilty. He answered the questions forthrightly. They did put on a cause of death defense, and in his closing, defense attorney indicates that the premier issue in this case is cause of death.
I actually think this defense was not so bad.
No.
Because it got in front of the jury, in effect, the whole cult thing, and that he might have been brainwashed, perhaps not to the point of lacking capacity
Correct.
completely. And then it got in the testimony. All you need is a reasonable doubt of some sort that the baby might have died from some other cause other than malnutrition.
Correct. And he indicates that he
Not
was...
terrific, but under the circumstances, not a bad strategy.
No.
And then he gets to get on the stand and, say, I want to atone for all of this, and, in a religious sense.
Correct. And I think what the defense attorney wanted to do when the defendant did take the stand was to humanize the defendant.
Correct.
These
So he's
facts are
doing his
unbelievable.
atonement, and he's also, looking for that reasonable doubt. And
Reasonable
of course,
doubt.
the evidence is such, and the crime is so horrible that it might be considered a long shot in front of a jury, but it's a strategy, and it's not an unviable
It is a strategy, and it's not manifestly unusual. Correct, Your Honor. He also focused in his strategy on trying to place the blame not solely on the defendant, so maybe there could be some kind of mitigation when they made their decision. He said he's someone willing to come before you and say something is wrong. He indicates that he was a scapegoat for the group, and that really Roland, Michelle Mingo, and the defendant's mother were really the ones who were forcing the starvation. If there are no further questions on that, I will go to the...
I'll touch on the Miranda issue
Okay.
for a moment.
Okay, sure.
Well, that's not really a problem, is it? At no point did
That's
he
not a
ever
problem.
assert a right to cut off the questioning.
Right.
And that's a lot different than someone saying, I don't want to talk about this because it's unpleasant or
Correct.
bothers me. Isn't that the answer to this?
Correct. He had already agreed to answer questions
And did answer a lot of them.
and did answer questions. When he was asked repeatedly about the circumstances of Samuel's death, the circumstances of his burial, also questions about Karen's reaction, he replied that he would not talk about his family, or he stared at the officers. 30 minutes into the interview, he asked whether he whether he cared for man's law, and he indicated that it was secondary to God's law. And then he gave a story of why he believed that. After he gives the narrative, he continues to answer more questions. They asked if he wore a raincoat, and if he wore the raincoat, he indicates, yes, I have a blue and yellow raincoat. Then he indicates, did you wear that when you walked the freeze-out trail? And the freeze-out trail is where they went in Baxter State Park to bury the body of the baby. And he indicated that time that he wouldn't answer the question, and they stopped the interview. He had already waived his right to remain silent. This is not a silence issue. And he did not, his silence was not an expressed unwillingness to continue with the interview. And finally, the closing argument.
Well, the instructions were accurate, were they
The
not?
instructions were accurate. He articulated that the jury was to consider both subjective and objective components of third-pronged malice. The subjective was subjectively the defendant knew. What he said was that he could see Samuel's emaciated body, he could feel his protruding bones, and he could hear his cries that something was wrong for 51 days. Trial counsel also indicated that the judge would instruct the jury on murder, and the prosecutor told the jury that their job would begin after listening to the instructions. And as I've expressed in my brief, I know I'm running out of time, but there was overwhelming guilt against the defendant, and that is also a factor that you are to consider in determining whether there's a problem with the closing argument. And I guess I'll just close with the 33E issue. The defendant filed a motion for a 25B2 motion at the end of the trial, and Judge Donovan wrote an opinion, and in that opinion she wrote that there was overwhelming evidence of first-degree murder, including the defendant's own testimony at trial. This defendant eliminated solid food from his 10-month-old baby, and because of that, Samuel did not celebrate his first birthday. He watched as Samuel became emaciated from and became from an active child to an immobile child. There was expert testimony at trial about Samuel's emotional and physical suffering, and the facts of this case show that the defendant committed a murder with extreme atrocity, cruelty. I will rest on the rest of my briefs unless you have any further questions, and I request that you affirm the conviction.
Thank you, Ms. Sullivan. Cheney, we'll take a short break.